Joinder, just the rules. 1. Joinder of claims. The court must have these three things over every claim. What are they? Subject matter jurisdiction. What are our three subject matter jurisdiction areas? 1. Federal question. 2. Diversity. 3. Supplemental. Court must have subject matter jurisdiction over every claim. Okay, let's talk about joining claims. The court must have what? That's right, subject matter jurisdiction over every claim, and that has to be what? Federal question. That's right, diversity. And 3, that's right, supplemental. Okay, joining multiple claims. The plaintiff joins multiple claims. The plaintiff may bring as many claims as she has, even if they are not related. However, the plaintiff must bring related claims or they are likely precluded. 2-prong, joinder of claims by plaintiff. Plaintiff may bring as many claims as she has, even if they are, that's right, unrelated. Plaintiff must bring related claims or they are, that's right, likely precluded, res judicata. Claim preclusion, same parties, same sides of the V, same transaction or occurrence, final judgment on the merits. Plaintiff must bring related claims or likely they are precluded under res judicata. Counterclaims, claims by the defendant against plaintiff. 2 flavors, permissive, compulsory. Permissive may be brought. They are not the same transaction or occurrence. They may be brought. Counterclaims, permissive. Same transaction or occurrence? No. And that's right, may be brought. Compulsory counterclaims by defendant against plaintiff. What do we need? Same transaction or occurrence. Must be brought by defendant or precluded. Permissive, what's our legal standard? That's right, not same transaction or occurrence, and they may be brought. They are permissive. Whereas a compulsory counterclaim arises from the 1, same transaction or occurrence, and they're compulsory. The defendant must counterclaim or that claim is precluded. Because they are from the same transaction or occurrence, the court will always have what kind of jurisdiction? Correct, supplemental jurisdiction. Multiple claims, plaintiff may bring as many claims as she has, even if unrelated. Plaintiff must bring related claims or likely precluded. Counterclaims, defendant against plaintiff. Permissive, legal standard, not same transaction or occurrence, may be brought. Compulsory counterclaims against defendant. What do we need? Same transaction or occurrence. Defendant, that's right, must file or precluded. And the court will always have, that's right, supplemental jurisdiction because, that's right, they are from the same transaction or occurrence. Number 3, cross claims. Cross claims against a co-party on the same side of the V. Are they ever compulsory? No, one is never required to sue the party on the same side of the V. You are never required to sue your co-party. Cross claims, are they ever compulsory? No. Why? Because you are never required to sue your co-party. However, they must be the same, that's right, transaction or occurrence as the underlying claim, the underlying plaintiff's claim. Cross claims, legal standard. They are 1, against a co-party. 2, they are never, that's right, compulsory. 3, they must be, that's right, the same transaction or occurrence as the underlying claim by plaintiff. 1, 2, 3, they are against co-party. Are they compulsory? No, never compulsory to sue your co-party, but they must be from the, that's right, same transaction or occurrence. Number 4, impleader. Defendant brings a new defendant into the lawsuit. That defendant is a third-party defendant. Legal standard. That third party may be responsible for some or all of the defendant's liability or for, you know it, contribution or indemnification. Okay, there's a deadline here for impleader. 14 days after serving the answer, otherwise by correct leave of court. Can the impleaded party file their own claims? Yes. Can the impleaded party implead other parties? Yes. Impleader. What's happening? Defendant is, that's right, bringing a new defendant, impleading a new defendant into the lawsuit because that third-party defendant is responsible for, correct, some or all of the defendant's liability or otherwise for, that's right, contribution or indemnification. What's our deadline? 14 days to implead a third-party defendant after serving the answer, otherwise by leave of court. Can the impleaded party file their own claims? Yes. Can the impleaded party implead others? Yes. Moving on to interpleader. Legal standard. Plaintiff in possession of property claimed by 2 or more defendants. 2, the claimants will litigate amongst themselves to decide who is entitled to the property. Legal standard, part 1, for interpleader. Plaintiff is in possession of property claimed by 2 or more defendants. An interpleader action is filed for the claimants to litigate amongst themselves to decide who is entitled to that property. All right, interpleader comes in 2 flavors, statutory and rule. Statutory interpleader, 3 prongs, nationwide service of process. As long as 2 parties are diverse, we have jurisdiction, at least $500 at stake, and a bond must be posted. Statutory interpleader. We have nationwide, that's right, service of process. What's our diversity rule for statutory interpleader? As long as 2 parties are diverse, we have diversity jurisdiction. And how much money must be at stake? At least $500, and a correct bond must be posted. Contrast, rule interpleader. 1, no nationwide service of process. 2, complete diversity of citizenship. 3, $75,000 in controversy. And 4, no bond. Okay, remember, let's run through all of those claims again. Joining claims. What must the court have over every claim? Subject matter jurisdiction. What kinds of subject matter jurisdiction are there? Correct, federal question, diversity, or supplemental over every claim. Plaintiff brings multiple claims. What are our two prongs? One, plaintiff may bring as many claims as she has, even if they are unrelated. Plaintiff must bring related claims or likely they are precluded. Counterclaims, plaintiff, defendant against plaintiff, permissive, do not arise from the same transaction or occurrence. Because they are permissive, they are a may, correct, they may be brought. Flavor 2, compulsory. These arise from the correct same transaction or occurrence. Defendant must file or likely precluded. Why will the court always have supplemental jurisdiction over a compulsory counterclaim? Correct, because it arises from the same transaction or occurrence as the plaintiff's claim. Number 3, cross claims are claims against a co-party. Are they ever compulsory? No, but they must be from the correct same transaction or occurrence. Number 4, impleader. What is happening? Defendants implead new defendants who may be liable for some or all of the defendants' liability, otherwise known as correct contribution or indemnification. What's our deadline? Correct, 14 days after serving the answer, otherwise by leave of court. The impleaded party may do what? File their own claims or to implead others for the same reason. 4, interpleader, legal standard. The plaintiff is in possession of property claimed by, that's right, 2 or more defendants. And what is the purpose? Number 2, claimants must litigate amongst themselves to decide, yes, who is entitled to the property. Interpleader comes in 2 flavors. 1, statutory. What do we get? Nationwide service of process. What are our diversity rules? 1, so long as 2 parties are diverse, we have diversity jurisdiction. How much money must be at stake? Correct, at least $500. And what must you post? Correct, a bond. Contrast, rule interpleader. Do we get nationwide service of process for rule interpleader? No. And our diversity rules are same as regular diversity. If we are bringing a case based on diversity, under rule interpleader, complete diversity is required. $75,000 in controversy, no bond is required. All right. Moving on to joinder of parties. Number 1 thing to remember, who cannot join parties who destroy diversity? The plaintiff cannot join parties who destroy diversity. May the defendant join parties who destroy diversity? Yes. Okay, 2 flavors of joinder for parties. 1, permissive. 2, compulsory, necessary or indispensable. Permissive first, 2 prongs, at least 1 common question of law or fact and arise from same transaction or occurrence. Permissive may join that party if they have 1, that's right, at least 1 common question of law or fact, and 2, arise from the same transaction or occurrence as plaintiff's claim. Moving on, compulsory joinder. Must be joined Permissive, permitted to join. Compulsory, must be joined. Remember, we have two flavors: necessary parties. The absentee claims an interest. Court cannot afford complete relief. Absence will impair that party's ability to protect their interest or subject an existing party to additional or inconsistent obligations. And of course, the court must have PJ, SMJ, and their joinder cannot, that's right, destroy diversity. Okay, legal standard, necessary party. Their absence will, correct, impair their ability to protect their interest. Compulsory parties who are indispensable. Legal standard, exclusion would prejudice them or an existing party. What happens if an indispensable party cannot be joined? Case may be dismissed, perhaps on a 12B motion. Legal standard, exclusion would prejudice them. What does the court look at when determining whether to dismiss the case or move forward without the absentee? Whether the court can reduce or avoid the prejudice by shaping relief. Whether the judgment would be adequate without the absentee. Whether the indispensable party could find relief in a different forum. Okay, easy, permissive, 2 prongs. Parties may be permitted to join if 1, at least 1 common question of law or fact, and 2, arises from, correct, same transaction or occurrence. Compulsory, must be joined if necessary or indispensable. Discussion 1, necessary party. Their absence will impair their ability to protect their interest or subject an existing party to additional or inconsistent obligations. Can the case move forward without a necessary party? Yes. Legal standard, the absentee's interest will be impaired or subject an, that's right, existing party to additional or inconsistent obligations. Contrast, indispensable party. The case might be dismissed, correct, perhaps on a 12B motion for failure to join a party under Rule 19. The exclusion would, legal standard, prejudice them or an existing party. What does the court consider? Can the court reduce or avoid that prejudice by shaping relief or by other measures? Would the judgment be adequate without the absentee? Could that indispensable party find, correct, relief in a different forum? Last type of joinder, intervention. A non-party claims an interest, wants to intervene in the litigation. 2 standards. Intervention as of right. This means it is a must. The intervener claims an interest in the litigation. If they're not allowed to intervene, that party cannot protect that interest. And existing parties cannot protect their interest either. What about permissive intervention? If it is permissive, it is at whose discretion? Correct, the court. What do we need? A common question of law or fact with the main action. Intervention. I want in. Non-party, That's right, claims an interest in the litigation. Intervention as of right is a must, claiming one must be permitted to intervene because that party claims correct an interest in the subject matter. 2, without intervention, that party cannot correct, protect that interest. And 3, the existing parties can't protect that interest. Contrast, permissive intervention. Who decides? The court. What's our legal standard? Common question of law or fact with the main action. Last topic, class actions, Rule 23B, mass torts. Who certifies the class? Correct, the court. Can you appeal that? Yes. Who certifies the settlement? Correct, the court. Can you appeal that? Yes, you can. Who certifies attorney fees? That's right, the court. Rule 23B, class actions. What are our diversity requirements? One representative diverse from the defendant and has a claim in excess of $75,000. What are our substantive requirements? There are 3. 1, the class action is the correct, superior way to resolve. 2, common questions predominate. And 3, putative class members are given, that's right, notice and ability to opt out. They are otherwise, correct, bound by the judgment. Okay, Rule 23B, class actions. What are our diversity requirements? 1 representative diverse from the defendant and has a claim in excess of $75,000. What are our substantive requirements? The class action is 1, the superior way to resolve. 2, common questions, that's right, predominate. 3, notice and ability to opt out of the class to all putative class members. Otherwise, those members, what happens if they don't opt out? Correct, they are bound by the judgment. Okay, Rule 23B, class actions have the 4 requirements of 1, numerosity, 2, typicality, 3, commonality, and 4, adequacy. NTCA, N, numerosity, T, typicality, 3, commonality, 4, adequacy. NTCA requirements. Numerosity means, yes, the plaintiffs are so numerous that joinder is impracticable. Typicality means, correct, the representative's claim is typical of those in the class. Commonality. There's a question of law or fact common to all class members. Same question of law or fact in common to all class members. And adequacy. The representative adequately represents the interest of the class. Okay, substantive requirements for a Rule 23B class action. 1, the class action is the superior way to resolve, correct. 2, common questions predominate over individual. And all putative class members have notice and ability to opt out of the class. Otherwise, correct, bound by the judgment. And what are our 4 requirements? NTCA. 1, N, numerosity. The plaintiffs are so numerous that joinder is impracticable. T, typicality. The representative's claim is typical of those in the class. C, commonality, same question of law or fact, common to all class members. And A, adequacy, representative adequately represents the interest of the class. NTCA. And that's it.